Today we are going to start from the beginning, the first part from the definition onwards, and I'll try to cover the as much as possible BNSS, the definition. PPT I make for all the provisions, etc. Some of the names I will skip because you can read yourself later on. I'll share PPT with all of you so you can get time later on to read it again. I request all of you, I already request all of you to please go through the provisions, initial sections of the section 2, the definition clause and others, and the initial 2, 3 chapters. And I told you as per syllabus I will do. So first class is on the basic definitions part, the functionaries which are there of criminal justice systems, courts, etc. So we will discuss that. Okay. So we all know the BNSS came into force from 1st of July 2023. There are many new definitions which are there in the Act, and some of them we have seen yesterday also. First chapter of the CRPC BNSS is on the preliminary section which we called. So initial section 1 to 5 of the CRPC. The same thing you will find in BNSS section 1 to 5. I deliberately left section 1. It's only title clause. Let me go to the definition part, section 2. So section 2, two clauses are there, clause 1, clause 2. So clause 1 laid down all the definitions. And clause 2 has incorporated the definition which are given either in the Information Technology Act or Nyaya Sanhita. So any definition which is not there in the BNSS, for that, if that words are defined in the Nyaya Sanhita or Information Technology, that definition will be followed. So basically incorporated the definition of other law for the purpose of criminal procedure. This definition we have seen yesterday is called audio video electronic means, new definition. It was not there in the old CRPC. The reason being that the BNSS or new criminal procedure which is there, this law has mandated that almost every single processes can be conducted by audio video electronic means, and I was explaining in the first class. So now someone can be sent by email, a person's statement can be recorded by video conferencing. Now police has to mandatorily record all search and seizure. So very important provision 105 of the BNSS. Accordingly, need arises that we must define this term also. So audio video electronic means. And if you see the broad wordings which has used, so audio video electronic means shall include now here when they use the word include, impliedly or you remember in the definition, any of the definition clauses, when the word includes are there, we see these are illustrative definitions. So that means there may be more things may include. So the definitions can be either illustrative or exhaustive. So here the definitions are the illustrative in nature when they have used the word includes. Now, after making the word includes, it has uses the word like any. It uses the word any. That means this electronic mode by the audio video electronic means which is there. Audio video electronic means you say shall include use of any communication device. The word any is there. When it is used, the word any implies it can be there. There are new method of communication device are being used. For example, 10 years ago, we have not thought of, or 5 years ago, we have not thought of our CCTV camera can be a communication device. But now it's possible that someone can stand in front of a CCTV camera and through voice you can communicate. So these are possibilities are there. With a smartwatch, you can communicate. So these any communication device by which communications can be made, those are can be covered here. That's why they use the word either any and include those words. So by use of word any and include, it is a illustrative definition where any system which can use for the purpose of communication device that cover under this law. Law has defined bail. This is a new definition. It was not there earlier. So in the CRPC, we used to understand bail, but there's no specific definition of bail in the CRPC. Now the law has defined the word bail. Now what we used to understand from the bail, the same thing is there. So bail means release of a person accused or suspected of commission of an offense from the custody of a law upon certain conditions. So basically, bail implies the release of a person on some surety, on some bond, and the same way the word bail has been defined in the BNSS. We find one more definitions, and this is about bailable offences. Now, I will discuss bailable offences definitions little later, because before that, we need to discuss offence. Now, what the BNSS has done is, when you look at all the definition clauses, they have arranged the law alphabetically. So, A, B, C in that way. So, you don't find the synergy that all places things in one places. So, summon case in one place, warrant case in another place. They should have ideally in one place. So, when it's a bailable offences, non-bailable offences are at different places. So, you will find that synergy you will not find there because the words are arranged alphabetically. So, bailable offense, I'll come when we discuss about offense, then I'll say bailable offences. Bail bond and bond. Bail bond implies when someone is stand as a grantor, third party surety. When you go to the court, you must have seen that there's advocate clerks, etc., who stand as a grantor and they submit the bond. So when someone third party stand as a surety or grantor, we call it bail bond. There may be occasion when may court say, okay, personal bond. So the person who is releasing himself is giving bond. So we call it bond without surety. So a person himself can give bond. Now, was it possible earlier? Answer is yes. Earlier also it was possible in the CRPC. So the bail could be on the own bond, bail could be on with the surety bond. Someone else can give you surety. That's possible under the law. But now the definition included the bail bond definition, bond definitions, both the definitions are there in the law. So what was in practice, the same thing has been incorporated here in the law, nothing else. There is a definitions charge. Now, when you discuss CRPC, there's no changes. In 2B, it was charge definition in the CRPC. But just for the clarification, if you have any doubt or someone might have doubt. Now, see the definition of charge, what does it say? Charge include any head of charge when the charge contain more head than once. Implied, a charge can be more head than once. Now, we have a specific class on the charge, framing of the charges and other things, trial processes. So when we discuss about that, we will discuss about this more than one head of the charge. It is possible in the trial, there can be multiple head in which the charge can be framed. So that's what the definition has said. So definition, the charge definition, in real sense, it has not defined the charge, but basically it has classified the charge. Charge can be with one head, charge can be more than one head. So in that way, it classifies. Then we have the definition of cognizable offense. Now again, we'll pause for a minute because I want to discuss offense first, and then I will discuss about the cognizable offense also. Now we come to complaint. Now very important definitions. With a view to his taking action under this Sanhita, that some persons, whether known or unknown, has committed an offense but does not include a police report. So the complaint definition says it does not include the police report. Complaint definition also says complaint to whom we make. We make complaint to magistrate. Many times, when someone go to the police station, and loosely we use the word that, okay, I file a complaint in the police station. Now, can a complaint be made to police? Legally speaking, answer is no. What we give to police is information that some offense is being committed. Though literally we use the word complaint because it is in the sense of allegations against someone. But legally speaking, the law has CRPC as well as the BNSS has used the word complaint in completely different context. Complaint implies allegation made, either you made oral or in writing. To whom you will make the allegations? To the magistrate. Why you make the allegation? Because someone known or unknown has committed some offense. What's the purpose? You have an expectation that the magistrate will take some action. So the complaints are always made to the magistrate. From here, what we can get the idea that the cases can be started in the magistrate court level, and accordingly we have a two main system of starting the cases, either through the police channel or through the court channel. So a person can go to the court and start a criminal case. So when a person goes to the court and start a criminal case, we call it complaint. It goes as a complaint, that someone make a complaint to the police about a cognizable offenses. Now we have not discussed cognizable offenses. We will discuss in soon. And the later on, police, after investigation, they found out the offense is not cognizable but non-cognizable. Then what will happen? The reason being, in cognizable offense, police has power to investigate. In non-cognizable offenses, police has no power to investigate. So when police started investigation, they had power to investigate. When police ended the investigation, they have no power to investigate because they found out to be a case become complaint. A case becomes non-cognizable offenses. When a case is non-cognizable offenses, then what to do? Because police has already devoted their time, they have devoted their energy. So the explanation wanted to give some remedy, and the remedy is that in those circumstances when police after investigation submit their report, which traditionally we use the word charge sheet. Now here it will not be considered a charge sheet, but it will consider as a complaint, and the police officer will be deemed to be considered as complainant. That's the answer given in the definition of the explanation of the complainant, and the police officer will be considered as complainant for those circumstances. Investigation. Now, therefore, yesterday we have seen this definition of investigation. So we know what the investigation means. I'm just skipping it. High Court. We know what the High Court definition is. Nothing to explain you. Remember, some of the criminal courts are established by the CRPC, now BNSS. Some of the courts are established by the Constitution. So High Court is established by the Constitution, and it has defined the High Court. Inquiry. There are three terms which we use in relations to criminal cases. One we call investigation, second we call inquiry, third we call trial. So basically, these three processes which are there under the, it was in the CRPC, it is in the BNSS also. Investigation, we have seen the definition. Who do investigation? It is police. Now, who do inquiry? Magistrate or court. Two words are being used. So inquiry means every inquiry other than trial, magistrate or courts. It implies that the criminal court can also conduct inquiry. Magistrate can also conduct inquiry. Now, when we use the word magistrate, we'll quickly look at the definition of classification of magistrate also. The magistrate can be executive magistrate, magistrate can be judicial magistrate. So both can do inquiry, that possible under the law. Investigation, we have just seen. So investigations, the cases try to define that all the processes is done by the police. Now remember the investigation when the police do, we'll look at the investigation chapter. There are many occasions when police completed their investigations, they submitted their report and they found some new materials. What to do now? So there is a power in which the police can do further investigation. In the new law, there are some changes also. The new law, they specified that even if there's some case which goes at the trial level, and at that point of time, there's some new evidences that appear, police thinks there's a requirement for investigation, the court may order, allow the investigation. So with the permission of the court, they can do investigation within timeline of 3 months, which are being probably 3 months, the timeline is given there. So we will look at that. So investigation implies the investigation which police is doing initially, as well as when police do further investigation. Remember, under the BNSS, the same thing was in the CRPC. Police can do investigation and the need arises to do further investigation. So that possible and the police can do. Judicial proceedings. There is a definition of judicial proceeding. Judicial proceeding includes any proceeding, the course of which evidence or is may be legally taken on oath. So we call it judicial proceeding where the evidence can be taken on oath. Local jurisdiction is basically the territorial jurisdictions, etc., which are there, and the law says we look at the jurisdiction chapter in the BNSS. There's a very detailed provisions on the jurisdictions issues, and we look into in the subsequent classes. So that basically territorial jurisdiction, what it implies. Non-cognizable offenses, I said we'll discuss that when we discuss about the offense. So we can again skipping for it for a minute. Notification means gadget notifications, etc. in P. Now we come to offense. The offense definition you might find in some other legislations also. The offense definition is was given in the CRPC. 2N is there in the BNSS also. Offense means any act or omission made punishable by any law for the time being in force and includes any act in respect which complaint may be made under section 20 of Cattle Trespass Act. I don't know what the relevance of this Cattle Trespass Act today, but they could have avoided it because that's included in any case. Now, what does offense imply? CRPC or BNSS, remember, it does not use the word crime. When we read newspaper, we use crime, criminal, crime is committed. CRPC and BNSS both has not defined what the crime is, but it is defined what is offense. And the definition is very clear, means any act or omission made punishable by the law. So either action or omission, both made punishable by virtue of a law. Okay, fair enough. Look, remember, the criminal law has to be very specific. We can't have a vague criminal law. Criminal law should not be very broad enough to include everything under the sky. Criminal law has to be very specific. When we use the word crime, crime is used in the theoretical perspective that some wrong which consider as an wrong throughout the world. So basically, from the point of view of acceptance as a wrong, something is accepted as a heinous thing, something accepted as a wrong by whole society, everyone. So someone has committed rape. No one can justify. Everyone says it's a offense, it's a crime. So there is a yardstick of acceptance of the thing as a wrong in the society, which must bring some kinds of a penalty or punishment. But say many of young generation students, as soon as you are in class for 2 hours, just go to outside Sudhanath Law College and take one cup tea, start smoking there. The smoking, is it a crime? Do we think it's a universal wrong? Like whole society accept it's a such bad thing that we must give punishment? Answer is no. You might land to a place in India where if you consume, you took chicken tandoori, you might go to jail. Is it crime? Answer is no, because it's not universally accepted wrong. Someone might, all young students, might be someone from Bihar, Gujarat, you just entered to Gujarat, and might be young student wanted to have just one bottle of beer. Now you may go to jail for 3 years. Now, is it offense or crime? No, definitely it's not universal wrong. Universally, it is not accepted as a behavior which attract penalty. Consuming alcohol, consuming cigarette, some kinds of a behavior, even adultery in many occasions. It was, now they have removed it. It was not considered as a universal something accepted as a wrong where the person should attract penalty. So when we use the word crime, crime is considered as a some kinds of a wrong which universally accepted as such a heinous thing which must attract penalty. But when we use the word offense, it does not talk about whether you accept or not, immaterial. Whether you like it or not, immaterial. Law says if you consume cigarette in front of a college, you is liable to be either fine or go to jail for 15 days or 1 month. Law says if you consume some tandoori chicken in some place where it is prohibited, you will go to jail or pay fine. Law says that if you consume someone any kinds of alcohol in Bihar, they will be jailed to 3 years or 7 years depending on circumstances. It is not crime, but it is offense. So that's why when we look at all the legislations, we talk about the offenses, we don't talk about the crime. Because as soon as we talk about the crime, the issues comes of universal acceptance of it as a wrong, which should attract penalty. But many kinds of these kinds of a wrong does not do not fulfill the requirement of such kinds of a penalty. And accordingly, any penal provisions throughout the globe, they don't want to go on those theoretical argument whether it is accepted as a wrong or not. X society may accept, Y society may not accept. So that's why it is offense. And when we say offense, you have rightly pointed out that many times omission. Now, some omissions might be universally accepted as a crime. Houses are being burnt, women are being raped by miscreants, and police is watching, enjoying. It's a war crime. It's a crime against humanities, etc. Now, can police say that, okay, it's not a crime, it's an offense? So, these are omission, police part, army part. Police is just sitting, army is sitting. there ideally without doing anything. They can't say it's not it's an omission, but omission also become some cases it can crime. So many crime against humanities, etc., may be attracting, which may come to crime. But when we say the penal provisions, etc., we use the word offense. So either act or omission, which law made punishable, it punishable, and that's why is the offense word is being used. Now, when we use this word offense in the BNSS as well as the CRPC, offense can be classified in different ways. And I deliberately have not discussed these words. It has been defined cognizable, non-cognizable. One classification of offense is cognizable, non-cognizable. Cognizable offense implies where police has power to take action. What kind of action? There are three kinds of action which police can do. So police has three kinds of power in cognizable offenses. What are those three power? One, in cognizable offenses, police has power to register FIR. Under old law, it was section 154 CRPC. New law, it is section 173 BNSS. First power. Second power, in cognizable offenses, police has power to investigate without order of magistrate. Under the old law, it was section 156 CRPC. Under the new law, it is 175 BNSS. Third power, in cognizable offenses, police can arrest without warrant. Old law, it was section 41. New law, it is section 35. So if these incognizable offenses, when we use the word cognizable, it implies police power. Three kinds of power: arrest, FIR, investigation. Impliedly, in non-cognizable offenses, police don't have power. All these three power they don't have. So they cannot register FIR, they cannot start investigation without order of magistrate, and they cannot arrest, except one minor exceptions are there. But general rule is they cannot arrest the person in non-cognizable offenses. So this is the first classification of offenses. Second classification of offenses are, we call it bailable, non-bailable. So some offenses are bailable, some offenses are non-bailable. What's the difference? It is not that some offenses are non-bailable, that does not mean the person will not get bail. The only difference is, in bailable offenses, a person has a right to be released on bail. It's not discretion of the authority. In bailable offenses, a person has a right to be released on bail. While in non-bailable offenses, person has no right to be released on bail. It is a discretion of the court, is the discretion of the authority. If the authority think they may release a person on bail, that is permissible under the law. So the second classification: offenses can be bailable, offenses can be non-bailable. Where we will find it? Where we will find it? We'll find in the first schedule of the BNSS. It was in the first schedule of the CRPC also. So you'll find a list of the column where it says the offenses which are bailable, offenses which are non-bailable. So if you have a glance, you can glance of it and you will find all those provisions of bailable, non-bailable. Third classification of offenses we can classify is, offenses can be compoundable, offenses can be non-compoundable. Idea is, compound, remember compound literally means mixture. Any compound it means mixture. So idea is that when both the parties are mutually agreed to settle the dispute, why we should create difficulty? Why we create a hurdle? So compoundable offenses implies where parties can themselves settle the dispute. When we look at the compoundable schedule, in the old law, it was section 320. New law, the number is just 3, somewhere around 330, 536, somewhere is there. There's a long list, and there's a 2 lists are there. One list says, even in those cases when the parties compound, magistrate has no discretion, magistrate has to allow it. So it does not require prior consent of the magistrate. Some offences when the party compound with the permission of the court. That means if the magistrate say that no, I will not allow compounding, magistrate may refuse it. So you'll find 2 lists are there. One list where the magistrate has discretions. Other list there is a no discretion which are available for the magistrate. In the compoundable, non-compoundable. So the third classification. So in the compoundable offences, the party can compound, settle the dispute. Non-compoundable offences, that means the parties cannot mutually settle the dispute. So it cannot settle by the parties. So there's a third classification. Fourth classification, when we look at the definition, you will find offences triable as summon case, offences triable as warrant case. Now, the CRPC or BNSS for that purpose, they have defined the word summon case and warrant case. Summon case implies where punishment is up to 2 years. Warrant case implies where the punishment is more than 2 years. And accordingly, the law laid down a different procedure, and we call it summon process, warrant process, summon trial, warrant trial. So these are 2 different processes. So because the definition, you will find the definition of summon case, definition of warrant case. From that, we can classify the some offences can be categorized as summon case, some offences can be categorized as warrant cases. In the same way, you will find in the first schedule, some offences triable exclusively by the session court, some offences which are triable by other than session court, so magistrate court. So in that way, we can, so offences can be, we can say, classify the offences in these 4 ways. And offences implies either act or omission made punishable by the law. And that's the offences definitions. Now again, we find the definition of officer in charge. Now I know you all have done CRPC, you have gone through it, but again, it's better to have a clear understanding of the topic. There's no changes from the old law. What was there in the old law? The same thing is there in new law. But many times when you visit police station, or you might heard from some of your friends, etc., that you went to register an FIR, and our officer in the police station say, okay, OC is not here. You come tomorrow. Come in the evening. OC, officer in charge. Now, what the law says? Law is very clear. Who is the officer in charge? And see the definition. It says, officer in charge of a police station include when officer in charge of a police station is absent from the station house or unable from illness or other cause to perform his duties, the police officer present at the station house who is next in rank to such officer and is above the rank of constable, or when the state government so direct, any other police officer so present, they are all officer in charge. So remember, you don't have any police station without officer in charge. If OC is absent, so in Calcutta, say, all the police station officer in charge, they are all inspector rank officer. So if the inspector is absent, there is additional inspector, he is officer in charge. If he is absent, then sub inspector, senior most officer in charge. All sub inspector is absent, assistant sub inspector can be officer in charge. All assistant sub inspector is absent, head constable can be officer in charge. So you see the way the language of officer in charge is given in the BNSS or CRPC, it will be rare that a police station is without officer in charge. So when they refuse that, okay, OC is not here, was they right? Answer is no. Very interesting thing is, when you look at the definition of officer in charge, there was a parallel sections in the CRPC, section 36, no number has changed in BNSS, which gives power of officer in charge to superior officer. And section 36 in old law, now the number has changed, where it says that all the officers superior to officer in charge, they can all act as an officer in charge. That means if the need arises from head constable to DG, for Calcutta from head constable to commissioner of police, everyone can act and discharge the responsibility of officer in charge. That's the way the law is being drafted, that will not have a vacuum. We have always someone who can take care of police stations. The cases can be started, cases can be investigated. And that's why this definition is important. So if you find same difficulty, you can show that, look, what is the officer in charge definition is. So if the OC is not there, the next person is officer in charge according to BNSS. And that was the same thing was there in the CRPC earlier. Place. Now, not much to discuss with you, but again, see here, what the word used. First word after place includes. I told you in any definition, when the word include is, it implies it's illustrative. So place includes a house, building, tent, vehicle, vessel. Because it used the word include, it means there could be other thing also. So it's a very broad definitions. Had they used the word place means a house, building, tent, vehicle, and vessel, then in those time only this means place, not otherwise. But by virtue of use the word includes, it is illustrative in nature, and there can be other thing which can also be considered as place. So someone might be on aircraft, might be rocket going to sky, place. Police report, the definition was same earlier. The report we submitted earlier under 173, now under 193. So after investigation, the police, we submit the report, we call it police report. Remember, many times we use the word charge sheet. There is no mention of charge sheet here, nor you will find its references in 1793, nor it was there in 173 CRPC. So why this word, we normally say charge sheet, but we don't, in the generally when we talk, we say, okay, police has given charge sheet or not, that's the word we used. So police report can also be classified into two categories. Police report, the law has used the word police report. So when after investigation, police submit their report, the report are of two types. One we call charge sheet, another we call final report. So the second categories are final report. So the CRPC or for that purpose BNSS, they use police report only. So whether it's a final report, whether it's a police charge sheet, both are nothing but police report. But when it is charge sheet, when after investigation, police is recommending for prosecution of the accused on the ground that there is a ample evidence available against the accused. That kind of report is called police report. Now, what happened normally in practice, many of you might have been gone to the court, etc. Some of you might, if you do internship in the Bankshal court, you will find the Lal Bazaar when they arrest some accuse a person theft of a motorcycle, etc. They tag them in 50 other cases. Now, the person might not have committed those 50 cases. So maybe one motorcycle theft case, you might see that in that case, there is 100 people in different occasions being arrested. Now that 100 persons cannot commit one theft. So when they submit their police report, what they do? They will submit the police report in the form of charge sheet in respect of the persons against whom the evidence is being found that he has committed offences. But then 50 other who were innocent and being arrested. Now, police has to submit report and say that they are innocent. So, the report which suggests, which exonerate, which release, which recommend that these people have not committed offences, they must be released from the case. This part of the report is considered as we call final report. So the police report can be two types. One, when the report suggests that the person should be prosecuted or police recommend the person's prosecution, we call it the report is in the charge sheet form. When a report suggests that, okay, no evidence being found against the persons, he must be released from the case, we call this final report. Now, final report again are two types. One we call final report true, other we call final report false. What does that implies? Final report true implies that the case is true, but no evidence found. So suppose there is a murder case where police arrested 10 persons and no evidence found against any of them. Murder is committed. So case was true. But against these 10 persons, police will submit a final report that they must be released from the case because they must be exonerated, they must be released. There is no evidence against them. Case was true. So final report true. Final report false. There may be occasion when someone has filed a false case, in completely baseless case. And then police is submitting final report. We call it final report false. So the final report can be two types. Final report true, final report false. So police report is submitted by the police after completion of investigation under 193 in the BNSS. When that report suggests that the person should be prosecuted, we call it charge sheet. When that report suggests that the person should be released because no evidence against them, we call it final report. So these are the two major categories of police report, either in the form of charge sheet or in the form of final report. Police station basically means a place which declared by the government. It can be any places. Public prosecutor, we'll discuss soon on the public prosecutor. So appointed under section 18, etc. That's the law says. Subdivision means a subdivision of the station. Summon case means which are not the warrant case. Victim, there's a definition of the victim. Victim means a person who has suffered any loss, injury caused by reason of act, omission, or the of the accused persons, and include the guardian or legal heir of such victim. So victim has been brought to cover the family member, cover the heir, cover the guardian. They can also be considered as a victim. In the old law, it was section 2WA. New law, it is section subclause Y. Victim, you'll find many cases where court has tried to define the victim. So in Jagjit Singh versus Ashish Mishra case, court says victim means a person who has suffered any loss or injury caused by the reasons of the act of omission of which the accused person has been charged. And the expression victims include his or her legal guardian, legal heir. So that's the definition basically which cover the victims. Warrant case. So summon case we have seen which are not warrant case. Warrant case means where the punishment is exceeding 2 years. So anything where the punishment is more than 2 years. So whether punishment is death, life imprisonment, or to more than 2 years, they are all warrant cases. So murder case, warrant case. Any case where punishment is more than 2 years, theft case, warrant case. So they are all warrant cases. Why it is important? Because the law laid down the process. Summon cases go for summon trial, warrant cases go for warrant trial. That's the basic principles. And in the complaint procedure, when we look at the trial also, we'll see some differences in the trial, the manner in which the trial is being conducted. It's a little difference is there. Then the last clause 2 says that the word if is not defined in the BNSS but has been defined in the Information Technology Act or Nyaya Sanhita, those definition will cover under this act also. So that's the definition what we have completed. Those are the basic definitions of which was there in the BNSS. Now we look into the functionaries part which are there. So so section 3, 4, 5 are the constructions. Now, section 3, why I asked you to read is under the new law, there is it's minor changes from the old law. When we look at the CRPC, there the definition of magistrate implies either judicial magistrate or executive magistrate. Now, in the new law, it used the word, when the word magistrate has been used in all places, it implies the judicial magistrate of first class or judicial magistrate of second class. So it does not, when they use the word only magistrate, that means the judicial magistrate first class or judicial magistrate second class. In BNSS, throughout the BNSS, you will find where there's the requirement of executive magistrate, the word executive magistrate is used. It's only magistrate is not used. The word executive magistrate is used. That was not the case in the CRPC. So CRPC, many places, the some magistrate may also implies executive magistrate because it was defined separately. So now in the BNSS, wherever the word only magistrate is used, it means either judicial magistrate first class or judicial magistrate second class. When it is executive magistrate, then executive magistrates are separately mentioned in the act. So in all BNSS, throughout the BNSS, you will find the references of executive magistrate. Uh, and then their role functions, etc. So when they have to do licensing, cancellation, they act are, so act has defined the act of the executive magistrate, what kinds of a role the judicial magistrate do. So remember, the executive magistrate roles are all executive in nature, administrative in nature, and they have a different kinds of power under the law. That's what he tried to explain in section 3. Then clause 4 talking, section 4 talking about the trial of the offence under the BNSS and the other laws. So remember, the trial process by and large was followed CRPC, now again BNSS. So if the still, even under the special law, the trial will be conducted under BNSS, again subject to some, though the special law has provided some other things then. So all offences under the BNSS shall be investigated, Nyaya Sanhita investigated, inquired, tried by these. All offences under special law shall be investigated, inquired, tried, or otherwise dealt with in accordance to the same provision, but subject to enactment. So if the special law talk about some specific things, then that will apply. Otherwise, BNSS provision will be applicable for the trial of special laws offences also. So say POXO trial, something which is different from the BNSS are there in the POXO that may applicable there, but otherwise the CRPC provisions is applicable under the law. Section 5 is a saving clause which was there earlier also. So nothing contained in this Sanhita shall, in the absence of the specific provision to the contrary, affect any special or local laws for the time being in force, or any special jurisdictions or power referred to any special form or procedure prescribed by any law for the time being in force. So it basically just protect the special laws and it will not going to adverse impact them. Now we come to the our next part, and the next part is basically functionaries. Remember, if you think that this entire criminal justice system is a drama, so there is a stage, say Kalamandir, and you are all watching drama. There are different persons who act there. So who are those actors in this entire drama of criminal justice system? So the people who perform there, who act there are criminal court, but we go to criminal court frequently. Police, very important functionaries. Cases started by the police always, which may include for the juvenile, we have different words are being used. Here the two words are there, CWPO, SJPU. CWPO implies Child Welfare Police Officer. From where we'll get it? JJ Act. child welfare police officer. AJPU, under the JJ Act again, there is a section we talk about specialized juvenile police unit. So in every district you have a specialized juvenile police unit which consists of CWPO, social worker and other senior officers, etc. So two functionaries. Third functionary is prosecutor. Fourth functionary is again defense lawyer. They also play a role. Correctional services personnel, probation officers. Then JJB CWC again is for Juvenile Justice Board, Child Welfare Committee, forensic experts. Now under the new BNSS, it is mandatory that where the offences punishment is more than 7 years, etc., the police need to take assistance of the forensic experts. Forensic evidence need to be collected. Examination has to be conducted. So that's gradually it become very important functionaries in today's life. Now, some of these functionaries are created by BNSS or rather earlier CRPC. Some of the functionaries are not created by the CRPC or BNSS, but they are given certain kinds of power to function. Now, from you again, which are the functionaries among these you think it created by the CRPC or BNSS? Now, new law, BNSS. Okay, definitely criminal court and prosecutors. Forensic experts creation does not comes directly from here, but yes, criminal court and prosecutors are by virtue of CRPC. What about police? Okay, police is not created by the CRPC. Police is given power under the BNSS or CRPC. Same way, correctional services, not under the CRPC. They are mostly state legislation. So like in West Bengal, we have West Bengal Correctional Services Act 1999. So in that way, different state has their own legislations which deal with them. Probation officers, we have a Probation of Offenders Act. There is a separate act under which they are being created and their role and functions are there under that role, but the sum of the powers comes from this act also. JJB, CWC, they all created by virtue of Juvenile Justice Care and Protections Act 2015. That is the latest law. Yeah, so that's basically the function. Now let me see one by one. So you will find in the chapter 2 of the BNSS, it talk about the constitution of criminal courts and officers. So first section talk about section 6. It was also section 6 in the old law. So CRPC also at the section 6. Now language by and large is same. Now when we see here the classes of criminal court, the first 3 word or 4 word is besides the High Court. And the court constituted under any law. So there can be courts under a special law. We have POXO under there's a separate court. There's other law which has a separate court. Protection of Human Rights Act has a separate court. So leave those courts, etc. And beside the High Court. Why they use the beside the High Court? Implied from here is High Court is also criminal court. Those courts constituted under the special laws are also criminal court. So under NDPS Act also we have a separate court. POXO we have a separate court. A Protection of Human Rights Act under which we have a separate court. So we have a separate court under the different laws. Other than that, the following are the criminal code. What are those code? Following classes of criminal codes. So from here also we can see in the top criminal code is High Court. But why they get separately all these? Because High Court is not constituted under CRPC. Which law create High Court? Constitution. The Constitution is the creator of the High Court and Supreme Court. So, other than that, these are the criminal court. Now, these courts are created by the CRPC or BNSS. What are the classes of criminal court? Court of Session, Judicial Magistrate First Class, Judicial Magistrate Second Class, Executive Magistrate. They are all criminal court. Now, interestingly, when you look the word Executive Magistrate is here as a criminal court, but Executive Magistrate do not conduct trial. Why it is so? The reason being, when you look at the provisions of taking cognizance, in the old law it was section 190, new law is probably 210 BNSS. Who can take cognizance? Now we should not confuse this word cognizance from cognizable. When we talk about cognizable, it was police power. When we say cognizance, it is the court power. Court take action. So when 190 of the CRPC or 210 of the BNSS talk about the cognizance, in that section you will not find the reference of executive magistrate. So executive magistrate are not criminal court for the purpose of conducting trial of offences. But executive magistrates are criminal court for the purpose of giving some directions which are by and large preventive in nature. And there they discharge some judicial functions or quasi-judicial functions. So that when we look at the executive magistrate both discharge judicial functions, non-judicial functions. So say in last 3-4 days, there was some kinds of a disturbances in Murshidabad. And just for sake the example, hypothetically, say executive magistrate in Murshidabad given the police order to fire on the mob. Now, this order of executive magistrates, when they give, is it judicial function? Answer is no. It's an executive function. But the same executive magistrate, when after hearing, pass an order, in the old law it was section 133 or 145 of the CRPC, now the section number has changed. When they act as a preventive mechanism, they act as in court, they act as in criminal court. So, in that sense, the executive magistrates are criminal court under section 6 has been defined. So, the executive magistrate give both kinds of functions. They do executive functions, they do judicial functions. So, there may be occasions when executive magistrates are doing executive functions. The same executive magistrate may do judicial functions. Remember that when we got the CRPC in 1973, one revolutionary change which was there in the 1973 Act was separation of executive from judiciary. Because the earlier law, even on many occasions, the executive magistrate used to conduct criminal trial, some smaller offences. But the 73 says no, complete separation of executive from judiciary, and executive magistrate cannot conduct that criminal trial. Now, this law is very clear, and this law, when we look at the executive magistrate provisions, some of the functions can be judicial, some of the functions can be executive. So, they are not criminal court in all circumstances. So, we should not blindly believe that, okay, someone is executive magistrate is always criminal court. There may be some occasion when an executive magistrate discharge judicial functions and they act as a criminal court. There might be some situation when executive magistrate act pure executively in the executive capacity, then they are not criminal court. So when we look at the hierarchy of criminal court, on the top we have a high court, then we have a session court, then we have a magistrate court. In the magistrate court, we have first class and second class. Your burden is less. In West Bengal, we don't have second class judicial magistrate. So it's only first class judicial magistrate. And then we have a executive magistrate for limited purpose. Now, within these magistrate, it may further classify by subsequent provisions. So these are territorial divisions. So every state shall be a session division or shall consist of session division. So normally every district is a session divisions. Many times when say new district is being created, then two district can be one session division, but gradually it shift to one session division. So every district can be a session division, and accordingly with the government can notify the way these divisions are being taken. So that's not very you can read, you can understand, nothing much to explain there. When we look at the court of session, so section 6 only says you will have high court, you will have high court. Below high court, we have court of session. Below court of session, we have a magistrate court. Now it says the government will establish court of session for every session division. That means every district can be a session division. So they will establish one court of session. Remember, the government will establish court, not the judge. When we look at the judge's power, etc., it is the high court. So cross 2. The every court of session shall be presided over a judge to be appointed by the high court. So who appoint the judge? High court. Why is this so? The government is establishing a court, but the judge is appointed by the high court. Separation of power. Independence of judiciary. Independence of judiciary is paramount. Who appoint executive magistrate? Government, state government. That's the difference between the judicial magistrate and executive magistrate. Judicial magistrates are appointed by the high court, while executive magistrates are appointed by the government. When they appoint the government, government can have a complete control on it. The high court may also appoint additional session judge to exercise jurisdictions in the court of session. So when you go to, suppose you went to Alipur court, so you'll find one session judge. Along with that, 10, 12, 13, 14, I think 15, 16 additional session judges are there in Alipur or in every district. So they are called additional session judge. They are all having session judge and additional session judge. They are having the same power. Earlier, there was a concept called assistant session judge. Now, new law has completely abolished the concept of assistant session judge. So, in session court, we don't have assistant session judge court now under the BNSS. So, now we have a session judge, additional session judge. These two right courts. Clause 4 permit that the session judge of one session division may appointed by the High Court to also be additional session judge of other session division. Now, these are the permissible provisions, because many times when a new districts are created, one person may be in charge of more than one places, but in practice, every district get their own session division. Clause 5, when the office of session judge is vacant, the High Court may make arrangement for the disposal of any urgent application which is or may be made or pending before such session court by additional session judge. Normally in practice, one additional session judge being made in charge of a session judge. So that's the arrangement under clause 5. Clause 6, the session court shall ordinarily hold its sitting at such place or places as the High Court may by notification specifies, basically court which are there, nothing to add there in the processes. Clause 7, the session judge may from time to time make orders consistent with the Sanhita as to distribution of business among additional session judge. Remember, judicial power of session judge and additional session judge are same, but administrative power of the session judge is more, because the who assigned the work to additional session judge under clause 7. So that means administratively, the session judge control, distribute the work among the judges of that additional session court. That's what the law has suggested. Clause 8, the session judge may also make provision for the disposal of any urgent application in the event of his absence or inability to act by additional session judge. So session judge also asks, additional session judge to discharge the duty, that also permissible. Clause 9, the session judge may also make provision for the disposal of any urgent application in the event of his absence or inability to act by additional session judge. So session judge also asks additional session judge to discharge the duty, that also permissible. Explanation has added, for the purpose of this Sanhita, appointment does not include the first appointment, posting or promotion of the person by the government or any service or the post in connection with the affair of the union or state, where under any such appointment, posting, promotions required to be made by the government. So it basically process. Jurisdictions will find the CRPC High Court has a jurisdiction to specify the place or places where the ordinary court session may sit within the division. Many times we find that for hardcore criminal, we took session court to jail premises. So entire trial is conducted in jail. That possible under the law. So that's law permit and it can be conducted. Exercise the power, session judge include additional session judge. He has all the power of jurisdiction of the session judge to try the offences. I said judicially, additional session judge has the same power as of session judge. So they exercise the same power for that purposes. Sabuddin case, Supreme Court says the High Court has the power to fix venue of trial inside the jail premises, can be exercised in respect of pending cases. So there are many occasions I said when trial is conducted in the jail premises, that possible. Now we come to Magistrate Code in section 9. And the 9 says, in every district there shall be established as many court of a judicial magistrate of the first class and the second class at places as the state government may, after consultation with the High Court, notify. So you have multiple magistrate, judicial magistrate first class, judicial magistrate second class. I already told you that in West Bengal we don't have a judicial magistrate second class. Here the posting, the first posting itself is a judicial magistrate first class. Provided that the state government, after consultation with the High Court, established for any local or one or more special court of judicial magistrate. Now the government may establish the special magistrate court. Since the government may tomorrow establish that in some places we have an enormous number of cases on NI Act, a special court just for NI Act. There can be special court just for 125 CRPC. Now the number has changed in the new law. So the government can establish. The presiding officer of such court shall be appointed by the High Court. Remember, court established by the government, judges appointed by the High Court. That's the division of power, the separation of judiciary, judicial independence, and the judiciary judges are appointed by the High Court only. The High Court may, wherever it appears to be expedient or necessary, confer the power of judicial magistrate first of the first class or the second class of functionary judge in civil court. So they may vice versa, they can give the power. So law says they can, civil court can give it power for the judicial magistrate. Now, so session court, one judge was session judge, there's an additional session judge. In same way, in a district, we might have a 50 judicial magistrate or 40 judicial magistrate. There is a need that some must be administratively control them. And accordingly, section 10 law talk about those things. So what the formula? So you have a maybe 50 judicial magistrate. What the High Court will do, one of the judicial magistrate first class shall be appointed as chief judicial magistrate. Clause 1. So in every district, the High Court shall appoint a judicial magistrate of the first class to be the chief judicial magistrate. So remember, every district has one CJM, chief judicial magistrate. Who is CJM? He is also judicial magistrate first class, but he is appointed as a chief judicial magistrate of the district. Now, we know that in every districts are divided into subdivisions. So maybe like 120 Pargana. So that CGM sits in the Alipur court, but we have Raipur court, we have Diamond Harbor court. Same way in north, we have Damdam, we have Barakpur, other places. So how to deal with those courts? Because they are subdivision courts. What the courts will do, High Court can again appoint one or more judicial magistrate first class as additional chief judicial magistrate. So the clause 2 says High Court may appoint any judicial magistrate of first class as an additional chief judicial magistrate, and such magistrate shall have all the power of CJM under the Sanhita. So that's why you will find in every subdivision there will be one ACJM court. Some subdivision, even there can be more than one ACJM court, two ACJM court. They exercise the same power of chief judicial magistrate. So now what's the hierarchy of the judicial magistrate? You will find we have at the top, we have a chief judicial magistrate. Then judicially equal to, but administratively lower, we have an additional chief judicial magistrate, which look after all subdivisions. Then we have a judicial magistrate first class. Then we have a judicial magistrate second class. In West Bengal, we don't have judicial magistrate second class. So the magistracy court goes to chief judicial magistrate first class, chief judicial magistrate, additional chief judicial magistrate first class. That's the basic hierarchy which is there under the law. In the new law, what we see. Remember, in the new law, I said in the last class I was telling to you that we have omitted the concept of metropolitan magistrate. So, like in Calcutta, in Bankshal, we have a metropolitan magistrate court. Now, under the new law, there is nothing called metropolitan magistrate. So, who they are? They are again judicial magistrate first class. Similarly, Calcutta is a district. So, some person who will be in charge, head of that district, called chief judicial magistrate. Below them, there will be additional chief judicial magistrate court also, and then the judicial magistrate first class. So there is nothing called the metropolitan magistrate court. So the head of metropolitan city, that they have a metropolitan magistrate court, Calcutta, Chennai, Bombay, they all gone now. So every place we have a uniform judicial magistrate first class. Now, legally speaking, there's no differences. The power was same. There's no differences, but yes, people used to call them their CGM, and so now that's a CMM. So now CMM things gone. Clause 3 says the High Court may designate judicial magistrate first class in any subdivision as the subdivisional judicial magistrate. That powers are there. Now earlier we used to call subdivisional judicial magistrate, but now most of the places one ACJM is in charge of a subdivision. So we don't call subdivision judicial magistrate. ACJM put in charge of subdivision. Clause 4 says subject to general control of the CJM, every subdivision judicial magistrate shall also have exercised such power or supervisions and control over the work of judicial magistrate other than the ACJM in subdivision. So law permit that there can be SDJM. SDJM can exercise the same power of administrative control power on the other judicial magistrate. Section 11, it was earlier also there in section 13 that the government can appoint a special judicial magistrate. So they can appoint a special judicial magistrate for a specific class of cases or for a specific area. That also possible under the law. Remaining you can read yourself. Section 12 talk about the local jurisdiction of the magistrate, that again they will notify under section 9, 11 what the areas are there. That will be High Court can time to time they can say. Subordination of the judicial magistrate. Remember, CGM is subordinate to session judge. So every chief judicial magistrate shall be subordinate to session judge, and every other judicial magistrate subject to general control of session judge be subordinate to CGM. So all the other judicial magistrate first class, they are subordinate to CGM. The CGM may from time to time make rules or give a special order consistent with Sanhita as to distribution of business among the judicial magistrates subordinate to it. So CGM may rules say that, okay, you can deal with these kinds of cases, you can deal with these kinds of cases. They may divide the work among the judicial magistrate, and that possible law permitted under clause 2. That was earlier also. So one function is what we have seen, the executive judicial magistrate. Now second functionaries are executive magistrate. Now very important functionaries. Section 14, earlier it was section 20. Some of the persons are declared as executive magistrate, functionaries. They are given power from the beginning, from the birth. Law says they are executive magistrate. Who are? So in every district, the state government may appoint as many persons as think fit to be executive magistrate and shall appoint one of them as district magistrate. So DM are executive magistrate. And normally, if SDM are executive magistrate, ADM are executive magistrate. So the state government may appoint any executive magistrate to be additional district magistrate, and sub magistrates shall have the same power of district magistrate and Sanhita under any law for the time being enforced as may be directed by the state government. So the DM, ADM, they exercise the same kinds of power, not only under this law, but also can be under special laws. You have a many special laws are there where executive magistrate play very significant role. You must heard of some law called Essential Commodities Act. Enormous power given to executive magistrate. You have an act called, you must have heard this word of the act called ITPA, Immoral Trafficking Prevention Act. Enormous power given to the executive magistrate under section 18. Had they used this power under 18, we could have get rid of all place of exploitations from Calcutta. There's a power given to executive magistrate, enormous power. So the government can declare DM as an executive magistrate, additional district magistrates as an executive magistrate. Some place SDM are also declared as the government can declare them an executive magistrate or any other government officers whom they direct. Clause 3 says, whenever in consequence of the office of district magistrate become vacant, any officer succeed temporary to the executive administrator of the district, such officers they will be executive magistrate. The state government may place an executive magistrate in charge of subdivision. So that's why we call subdivisional magistrate SDM. So in subdivisions also there is executive magistrate. So DM are executive magistrate, SDM are also executive magistrate. The state government may by special order, subject to general control of the DM, etc. They may delegate this power to other officers also. So government may by general special order and subject to control and direction as it may deem fit to impose, delegate its power under subsection 4 to district magistrate. So government can their own power they can delegate to the DM, executive magistrate. Clause 6, I put red color. It was earlier clause 5. Now earlier in the CRPC system, it was the only commissioner of police who can act as an executive magistrate. Under the new law, we got a separate section also. Next section 15, I look at that. But before that, it's the same provision. So clause 6 says, nothing in this section shall preclude the state government from conferring under any law for the time being in force on a commissioner of police all or any of the power of the executive magistrate. So the government can confer the power of executive magistrate on commissioner of police. So in Calcutta, commissioner of police is executive magistrate. Previously, they were executive magistrate under section 20 clause 5. Now they are under section 14 clause 6. You might have been seen when this all agitations were going on Arjikar issues. Many times we see advertisement in the newspapers came from the Commissioner of Police Calcutta that in exercise of power under so and so under 14 clause 6 of the BNSS, they direct that okay, no procession in this state, no movement on that state. From where that power comes? Or the Commissioner of Police passed that order, restraining order, that Michelle will not go from this road. Because they are executive magistrate under section 14 clause 6. Earlier, they were executive magistrate under section 20 clause 5. Now, while Commissioner of Police acts as an executive magistrate, interestingly, the district police were never given power of executive magistrate. So there might be some officer who are senior to commissioner who acting as a DG. Commissioner can become an executive magistrate, but the Director General of Police can't. That was not there in earlier provisions. But now we got a separate section. This is a new inclusion. Section 15. And the section 15 says that government, if thinks appropriate, they can appoint any officer superior SP or above rank officer. So police officer not below the rank of SP. So SP and above rank officers, they can appoint as executive magistrate for either a specific area or a specific class of offences. So for a particular area or for performance of particular function. So might be they can declare that, okay, this SP may act as an executive magistrate under ITPA. The SP may act as an executive magistrate under the your Essential Commodities Act. Or executive magistrate act as an executive magistrate within this area, subdivisions, etc. They can give the power. So the government may empower SP or superior officers as executive magistrate. Now, this is very significant change. Remember why this significant change is? In the district administrations, DMs are always considered as superior to the SP. One of the reason was that DM exercised executive magistrate power while SP don't. Now, under the new law, SP can also exercise this power. I think it's a good thing government can give this power to the police, because many things they can do as an executive magistrate under the act, that permissible. So like under the police act, under the arms act, there are many legislations where the executive magistrate's roles are there. ITP already told to you. There are many legislations where they have a power. So police can exercise that power if the government notify them as an executive magistrate under section 15 or other. Earlier also there's a separate section for executive magistrate. That's the issue arises here in Maharashtra versus Muhammad Salim Khan. Executive magistrates are nevertheless executive magistrates and are entitled to exercise power under the code. So state of Maharashtra versus Muhammad Salim Khan. Section 15 has now given widened the power, and they empower the police also to act as an executive magistrate. If the government can notify, they can act as an executive magistrate. Local area of executive magistrate, we know the government can notify. So district or subdivisions, etc. In that way, nothing much to explain to you on it. Subordination of executive magistrate, in the same way the DM is at the top, then SDM is the ADMs are there, then SDMs are there, etc. Those hierarchies are there. Now we come to, so we done two functionaries, court and executive magistrates, two functionaries. Now we come to third functionaries. Now very important functionaries. Public prosecutors. There are some change here also from the old law. So first, High Court, the central government can appoint, state government can appoint, they can appoint public prosecutor. Provided that they added for National Territory of Delhi, you know how when the Kejriwal government was there, how they were fighting with the central government, always there was some fight. And when they passed this law, they at that point of time, the BJP did not have government in central. Otherwise, they would not have added this also, because they don't, that conflict could have gone then. So they added this, that National Territory of Delhi, central government will act as in for public prosecutor, that they wanted. So it's basically who control prosecutors. So we see the conflict between the state government and central government, particularly in case of Delhi, and they added these because the central government want to control. In fact, any government in the country who are there, they always want to control prosecutors. And I'll say legally you can establish why they want to control, and which provisions indicate that they want to control it. Clause 2, the same way state government or the central government, they can appoint the prosecutor for any specific areas, etc. Clause 3, for every district, the state government can appoint the public prosecutor, and one of them as an additional public prosecutor. They can also act as a public prosecutor for other districts, etc. Those are permissible. Clause 4, DGM shall, so this same provision was there also, how from where the public prosecutors are being the district prosecutors are being appointed. So the district magistrate, they prepare a list of the cadre of the people. From there, one person can appoint a public prosecutor and one person appoint as additional public prosecutor, etc. So clause 4 says the district magistrate shall, in consultation with the session judge, prepare a panel of the names of the persons who are, in his opinion, fit to be appointed as public prosecutor or additional public prosecutor. So the DM, in consultation with session judge, prepared this list for appointing as a public prosecutor. Clause 5 says no person shall be appointed as public prosecutor or additional public prosecutor unless their names are there in the list. Now, there is no difficulty here till now. Now we come to clause 6, and very important clause. And that's why I put red color there. Now, clause 6 says, and very interesting, it says, notwithstanding anything contained in clause 5, that means the panel issues, list prepared by the DM, etc., whatever is there, leave it. It says, where in a state there exists a regular cadre of prosecuting officer, the state government shall appoint a public prosecutor or additional public prosecutor only from among the persons constituting such cadre. It defined what does regular cadre implies, and the explanation says regular cadre means a cadre of prosecuting officers which include herein the post of public prosecutor by which name called. So we have assistant public prosecutor or promotion which may provide for promotion of assistant public prosecutor by whatever the name called to that post. Prosecuting officer means by whatever name called, appointed to perform the functions of public prosecutor, special public prosecutor, additional public prosecutor, assistant public prosecutor. So clause 4 says, where there exists a regular cadre of prosecuting officers. We are in West Bengal, accordingly, I am giving you example from West Bengal only. So West Bengal, for all assistant public prosecutor, a large number of them, they are all appointed through West Bengal Public Service Commission. They got salary, they are salaried people, and accordingly they fulfill the requirement of cadre of prosecutor. They are prosecuting officer for the purpose of this clause, clause 6. The same language was there in the old law also. If you look the CRPC, clause 6 of section 24, you will find the same language. So ideally, the public prosecutor should have been appointed from among the assistant public prosecutor cadre which exists in West Bengal. But have you seen any district where the public prosecutors are appointed from those prosecuting cadre? Answer is no. Just have a look, you can look yourself, the clause 6 of section 24 of CRPC. How many state make amendment? Almost every state make amendment in 24 clause 6. Some state make amendment that point and say, shall they amended and they may. Some state says, however, if the state thinks there is no competent persons available, etc., they can appoint from the panel prepared by the government. So the government is always happy to appoint the public prosecutor not from the cadre but from the panel. Why? Then they can appoint their people. They can appoint, is always a political appointment. So you will find when there is a CPM government, their people might be the public prosecutor. Now the new government, these people might be public prosecutor. Tomorrow, if any new government will come, you will find the complete prosecutor will change. Now, ideal criminal justice systems in the world should not have these kinds of a criteria, where by changing the government, you change the entire cadre. And that's why the requirement was that if in any state there is a cadre of prosecutor, you should appoint the public prosecutor from them. But this is one agency, one group of the people. Within criminal justice systems, government always want to control. And because the government want to control, and it's not only for West Bengal, throughout the country. The government want to take control on the prosecuting agencies. That's the reasons you will find rarely any state had implemented clause 6 of 25 of the CRPC. Now, considering those state amendment, in the BNSS, they have added a proviso. What is the proviso says? It says, provided that where in the opinion of the state government, no suitable person is available in such cadre for such appointment, that the government may appoint person as public prosecutor or additional public prosecutor, as the case may be, from the panel of the names prepared by the DM under subsection 4. So now this kept the option open for the government to again appoint the public prosecutor from the panel which is being prepared. Now this kinds of amendment was there by the state earlier. Now in the main law it has been added. I think they have done injustice. They should have stick to what was the clause 6 earlier, that the prosecutor should be from the cadre. Remember, when the appointments are from the public service commissions, PSC appoints them, judges are appointed by the PSC, APPs are appointed by the PSCs. It gives some kinds of a sanctity, some check that we can get good quality of prosecutors. There are many good quality of prosecutors working in the magistrate court, but those people born as an assistant professor die as assistant public prosecutor. They die as an assistant public prosecutor. Despite having their potentiality, they don't get promotion. There's no avenues for promotion. Now, this was an option by which those people, the competent people, could have been promoted to your public prosecutor, etc. That options was there. So that's the clause 6. Clause 7 says a person shall be eligible to appoint as the public prosecutor. They laid down the qualifications. So 7 years of experience as an advocate. Then you require for a special public prosecutor 10 years of experience under clause 8. Both center can appoint, state can appoint. For the purpose of this period, the period which they work as an additional public prosecutor or assistant public prosecutor, will that be counted? This says we can take into account. So that's the basically provisions there. For public prosecutor, you will find enormously number of literatures which are available. When I says that many times these government agencies, they always want to control the prosecutors. There are many interesting cases. If you want to read, there's a case called Abdul Aziz versus State of Karnataka. All of you must have heard the name of Veerappan, a very famous criminal. I think cinema also came his name. Veerappan once abducted Rajkumar. And when abducted Rajkumar, suddenly he became a criminal, become politicians, and he started demanding from the government that you make a road in the jail, etc., etc. Very interesting judgment to read. Abdul Aziz versus State of Karnataka. You'll find all the negotiation between the government and Veerappan. So one journalist who used to negotiating vice versa, etc. Last demand of Veerappan was that his colleagues were in the jail, his comrades were in jail, or associates were in jail. He wanted their release. And so he wanted their cases to be withdrawn. So government appointed a special public prosecutor. He filed an application for withdraw the cases. Abdul Aziz was the father of a policeman who was killed by the Veerappan. So he went to Supreme Court directly. And Supreme Court in that case discussed about what kind of a role the prosecuting agencies discharge. It's the public functions. They are not representing the police. They have to discharge independent duties within the judicial system. So these people who discharge their duty will find many cases where the law talk about the duties of public prosecutors. You'll find many cases which are there on the prosecutions, are where the government, when they appointed, immediately they ask the public prosecutor to withdraw the cases. Now we see so many bulldozer justice in Uttar Pradesh. This current chief minister, when he became chief minister, he appointed public prosecutor, special public prosecutor to withdraw all the criminal cases against him. When Jagannath Mishra became Chief Minister of Bihar, he appointed a special public prosecutor to withdraw the cases against him. Nandini Satpathy, there are many examples, 100 examples are there, where the politician, when they go to the power, they appoint a special public prosecutor to withdraw their cases. So very important power the public prosecutor exercise, very important role they play. And accordingly, the government want to control that agencies. So this case, public prosecutor of a state of Kerala, where the assistant public prosecutors are member of regular government service having their separate cadre, where public prosecutor and additional prosecutors are appointed on the contract basis for a fixed period, and thus their posts are tenure posts. The state government is not bound to appoint the public prosecutor, additional prosecutor from the cadre of assistant public prosecutor. Said the clause 6 issues was comes. Deepak Agarwal, though the public prosecutor is holder of public office and hold post, yet he is not a government service. Public prosecutor is an office of the court, is an officer of the court. They're not salaried people. State of Maharashtra, Sundar Pandit, public prosecutor is not part of the investigating agencies, but is an independent statutory body. Public prosecutor, special public prosecutor appointed for the trial, held cannot represent the state government in appeal and revision. Okay, we already comes to 10. We can there are many things which we need to discuss again on the public prosecuting agency issues. So we'll stop here. In the next class, I'll initially complete this and then we'll proceed to the next topic.